Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Our topic for today is premature release. So, this is also another decision from the Honorable Supreme Court of India. So, before ordering or before cancelling the premature release, the court should think of, or the concerned authorities should think of the previous conduct, the behavior of the convict in the jail and his past history and also any danger to the society. All these things have to be considered and you have to make a reasoned order. Simply saying that he is not fit to release him is not sufficient. So already we have discussed at length about this point in ratio, decidendi, other aspects. Now here Supreme Court observed that the applicant apostrophes past history, criminal history or prior criminal history, conduct and behavior in jail, right? Possible danger to the society, etc. They are all the relevant consideration while considering application for a premature release. So this relates to the case Sharafat Ali versus State of UP in criminal writ petition WP criminal number 439 by 2021, decided on 10th February 2022. You can see the citation in Live Law 2022 SC 179, 3 judges bench. So Honorable Justice D.Y. Chandrachud, Honorable Suryakant and Vikram Nath, they have combinedly delivered the above judgment, right? So please remember, if you go into the details of the case, so this appellant or Sharafat Ali, he is not an ordinary man. He was convicted in a murder case and actually conviction for life, I believe. He has so far undergone 17 years, 9 months and 26 days. That is at the time of filing the premature release petition. He was in jail for the past 70, almost 18 years, you can say. And you may be knowing, according to section 31 CRPC, unless it is mentioned that the life imprisonment means life till he breathes his last, life imprisonment is only 14 years. CRPC. However, whatever big punishment you can undergo, ultimately how many concurrent all these things are there, the life imprisonment is 14 years. That's why we are under the impression that ఎవరికైనా లైఫ్ ఇంప్రిజన్మెంట్ 14 సంవత్సరాలు అనే భావంలో చాలామంది ఉన్నాం. 31 సిఆర్పిసి మీరు చూసుకుంటే అర్థమవుతుంది. కానీ ఇప్పుడు లేటెస్ట్గా ఏంటి చనిపోవడం, లైఫ్ ఇంప్రిజన్మెంట్ అంటే టిల్ అతను చనిపోయేంత వరకే క్లియర్గా రాస్తే తప్ప ఇప్పటికి కూడా 14 సంవత్సరాలు, ఎందుకంటే అమెండ్మెంట్ రాలా 31 సిఆర్పిసి, రైట్? ఇతను he was there in the jail for so many years, therefore he asked for premature release. అయ్యా ఆల్రెడీ 14 సంవత్సరాలు అయిపోయింది కాబట్టి నన్ను బయటికి వదలండి అని పెట్టిన తర్వాత now he submitted an application for a premature release and it was rejected. So rejected grounds ఇక్కడ చూడండి, విచిత్రమైన గ్రౌండ్స్ రాసి. The order of rejection stated that if he is released prematurely, there will be resentment among the family of the deceased persons. That means he may be attacked by the family of the deceased persons because they may also try to take vengeance against him. Second point, he may commit an offense, some murder again. There is likelihood of his committing another offense once again. And secondly, his nature, he is an extremist by nature. That means extremist by nature means not the terrorist. So he takes extreme decisions. Suppose if he wants to, if he is having the sudden grave provocation, he will kill anybody. So he is having the so-called extremist nature. He will go to the extent. And therefore, and the presence of bitterness among the parties. That is, please remember, so there are still disputes between the deceased family and this accused person's family. So in these circumstances, it is not safe to order for premature release. But Supreme Court pointed out, these are not the relevant points. These are not the concern points. What are the concern points? Number one, so previous history, how the offense has taken place. Are there still warring groups in the village? Or if he goes out, they may try to kill him. All these things. Simply to say that the family of the deceased are still having resentment. What is the resentment? So if they had written that they wanted to take vengeance against him, it would have been sufficient. This is what is called previous history. Second point is, so his behavior in jail. This has also to be taken into consideration. How he behaved in jail, whether still he is rude enough, whether he is in the habit of attacking the co-jailers also. So his behavior, whether he behaved very silently, very coolly, all these things have to be taken. That is his behavior in the jail. And third point, danger to the society. This is also enough. So if he is released on bail, so 1 murder, 10 murders makes no difference. So if he is likely to commit once again any murders, all these things have to be given. They have to be given in a speaking order. Then only these things, whether he will be released or not, will be considered. So once again, so actually this writ appeal has been allowed, but it was sent back to the concerned authority for the reconsideration of his application. Reconsideration, why? Basing on the points noted by the Supreme Court. What are the points? Previous history, behavior in jail, danger to the society. These points have to be clearly mentioned. That means they have to be inquired, mentioned, and then only so a decision has to be taken whether he can be released prematurely or not. So in this connection, please go back to our renowned case, very celebrated case, Rudolph Shah versus State of Bihar, where it was clearly stated that a person cannot be put to more than 50% of the sentence period in jail. Suppose if the case is of theft, if 3 years punishment is there, if the person is in jail for 1.5 years without regular trial, he can be released on bail. So when that is the nature of the court, then how can you keep him for years together? That too, a person who has already been in jail for about 18 years. So almost he might have lost his vigor, and might have lost his strength also. What is that he can do? But anyway, it is for the state to decide in this particular topic. So Supreme Court has 100% clearly stated that while considering the premature release application, you have to follow the 3-point formula. If you know these 3 things, it is sufficient. Okay, thank you very much.